The House Leader for the third party.
Yeah, thank you, Madam Chair. And I rise to speak to Bill 19, the Children and Family and Community Services Amendment Act number 2. So many times bills in this, or acts, have been opened multiple times. And this is the second time that this act gets opened this session, and amendments get made in amending both the Adoption and the Child and Family Community Service Act. This indeed is one of the, I think, most tragic chapters. If there was a book of British Columbia, the child welfare system is the saddest chapter of that. It's the chapter that causes our province the most embarrassment out of them all. And as I spoke to in the previous bill around Indigenous language preservation and the responsibility that the Crown Government holds in making sure that there's an ample amount of resources available to restore and protect Indigenous languages that are seeing fewer and fewer fluent speakers. Indeed, as I mentioned, some have no speakers. The child welfare system in this province is where much of the work of previous generations of elected officials that sat in these seats is visible today. And to think that this is a past problem that we have in our province would be a mistake. The problem is current and it's ongoing, and it's built on the premise that basically you can't trust Indigenous people to look after their own children. And that's what the whole system was built on. And the absolute devastation and destruction that the residential and day schools caused in our communities, the result of it has been crushing poverty in our communities, broken families, intergenerational trauma, intergenerational struggles. And so often when a child welfare worker shows up to a place, they confront that reality every time. And so the result of a series of policies has the Ministry of Children and Family Development little options, frankly. Failure of providing adequate housing, First Nations. I just read an article the other day about the infrastructure gap. We've got an infrastructure gap in communities across the province. The infrastructure gap in First Nations communities is far wider, far deeper, far more problematic. First Nations communities in urban areas that haven't had access to proper drinking water. And so there's no doubt that in those scenarios, legislated poverty, poverty by policy, which is what we see in First Nations communities, federal government decisions have led to this. The Ministry of Children and Family Development have been on the front line separating children from their families, sending them to group homes, sending them to foster care, breaking families down, breaking communities down. And that is the challenge. Breaking identity. As I talked about, there's a lot of connections between the bill that just passed second reading and the one that we're debating here. A lot of the same policy tools were used to separate Indigenous peoples from their territories. And they're hard topics to discuss. And as we, as a province, begin to follow the federal government's lead through courts Actually, should say probably follow the lead of the courts. The Crown governments have been scrambling to keep up with the decisions, what they're forced to do, what governments are forced to do. We see the bill last year, Bill 38, and now we see these amendments here. This bill that's in front of us today will expand the scope of joint consent-based decision-making. Legislative changes will allow for Indigenous governing bodies to enter into the power or duty agreements with the minister, requires any agreements and amendments made be public, removes requirements of the Lieutenant Governor and Council to approve the agreements and requirements under the Declaration on the Rights of Indigenous Peoples Act, provides for further appeals to the Supreme Court and Court of Appeals if the provincial court has jurisdiction in relation to a legal dispute arising under Indigenous law. Today, we're building upon the changes that were made through Bill 38 last fall, through the fall of 2022, the Indigenous Self-Government and Child and Family Services Act. It's a result of requests that were made from the Minister from Indigenous governing bodies to broaden the scope of joint and consent-based decision-making, to encompass most decisions taken by a director, as the Minister stated, under the Child and Family Community Services Act and the Adoption Act. Indigenous governing bodies were seeking to align, to sign agreements such as developing care plans, voluntary agreements, similar to the duty of directors, rather than the statutory powers regarding procedures. You know, we're just in the process of understanding the deeper implications of what this bill will do. But just as I talked at great length in the previous bill, the resources in order for the rebuilding, the reconciliation, the reconstruction need to be available. And the mechanisms in which those communities who are taking back the control of child welfare in their communities need to follow those communities. These Crown governments were responsible for that destruction. The source of it is here. We often blame Indigenous communities for being in the position that they're in, but the reality is that it's because of Crown government policy that crushing poverty exists. And for the vast majority of the decades that Indigenous people have been facing this policy decisions, the poverty that's resulted is because of a lack of ability to generate own source revenue in an effective way. We had a bill earlier that was, soon it will be the first time that Indigenous governing bodies, or First Nations, actually, more correctly, First Nations can hold land under the name of the First Nation. So there's lots of laws around how Indian reserves and First Nations can hold land. But what we see here is the Crown government, from everything that I've been told about this, we see here the Crown government that played a major role in breaking, in disrupting First Nations, handing the responsibility back with not the resources in place to be able to properly administer it. Potentially facilitating another situation where Indigenous people will be blamed for the failure of not being able to manage the child welfare system that we gave back to them. Is that where we're at? Are we at a situation where Indigenous communities that have gone through this process, that have gone through all of the changes that were made in Bill 38, the Indigenous Self-Government and Child and Family Service Act, taken back the jurisdiction of child welfare in their communities, but yet given none of the resources that the provincial government's child welfare system previously used to support those children? And we'll be asking many questions about this. Because it's not good enough to simply break the system, cause the damage, and then say, here, it's yours. Good luck. And so we need to see from the government that's passing these legislations, this one here today, the one 2 years ago in the fall of 2 years ago, of 2022, that the resources that were initially set aside for the children that come from those communities, the responsibility for is now going back to their home communities, that those resources are following the children to the administrators within their community. So that those administrators within the community of the child welfare services, the child and family services in those communities, are not constantly moving money around and trying to desperately do the things that are needed. We know that this government spends, $160,000 a year per child into the child welfare system, up from $135,000 a year. Is that money following? Is that money now available for kids that are no longer in the system? Does it stay in the system, or does it follow the children to the communities? And I think that it's really important to note that this ministry is not just handing the jurisdiction back with none of the resources in order for those communities to be successful. My understanding is that that's the case, and I certainly hope that by the time we get to the committee stage, that can be made clear. And I really hope that when I look back at this part of this speech, I can be reassured that everything that I just said was a moot point, that I was misinformed. That would be the best day for me to learn that I was misinformed about this whole part of this speech. And so we do need to acknowledge that there have been people in our communities who have been fighting to get the responsibility of the child welfare system back within our communities, look after our children, been fighting with this government to get information about our children who are no longer in our communities but who are in the system. This government's been hoarding the information. We can't give it to you. It's privacy information. We hope that the information follows as well, so that the administrators of our child welfare systems are not fighting this government to ensure that they know, that we know who all our kids are and where they are, our youth, so that we can maybe get them to that language that I was talking about just a few minutes ago, so that they can start to understand who they are and how they're connected and who their families are and how they're connected to these communities. So I'm happy that this policy is beginning to take shape. I'm really thankful for the First Nations in the province that are at the front end of this, and all of the people who have worked to move this forward. I'm really thankful for them. And, I just want to acknowledge that there's some serious resourcing issues that need to be addressed, that the jurisdiction isn't going back lacking resources. That now it's not just, oh, here you go. So then the government can stand up and say, we've never had fewer. I think successive ministers of child and family development, the number's been getting better and better and better, from the first minister of child and family development under this BC NDP government to now. The numbers have been consistently getting better. And, the current minister and the future minister is going to be able to say, as First Nations communities, it's gotten so good under us, under our government. There's never been fewer Indigenous kids in care. Never been so good. But yet when you go to those communities and you say, how well resourced are you? That they're going to be able to say, yeah, we're good. We got the money that we need in order to be able to deliver the service. Because it's not, the situation isn't, like, it's not a utopia, right? The damage has been done. The policies have been in place for decades. The intergenerational impacts are well known. I'm not going to repeat them again here. And so we're not handing over an untroubled situation. We're handing over a situation that is of the most desperate in many cases. And it needs to be linked with the housing policy. It needs to ensure, you know, at the rate of $160,000 a year that those children currently get in our system, that would be enough to, and if there's multiple children in the system for the family, that would be more than enough to really, really well house that entire family, like super well house that entire family, especially in the reserve scenario. Are those resources going to ensure that these children who have now come under the jurisdiction of their communities, are those resources going to go to ensure that those families have access to the money to build or to maintain, to have a home that can house everybody? Because that would be remarkable. My sense is it's not, but I'm hoping in committee I learn that I'm wrong. Because we know a lot of these child welfare cases are as a result of other health and social concerns. And so there needs to be a coordinated effort that looks at that. And coming from a First Nations community, I know that it's the thing that our leaders struggle with the most. It's the most challenging file for any newly elected chief and council member. You get child welfare. There's no support for those people. You know, when I look across the street to my municipal council colleagues, nobody gets child welfare as their portfolio. They get sewer and water, or they get parks. It's a good one. They get development, planning. They get all the things in a municipality. Nobody in municipal governments gets child welfare when the child welfare person calls up. And that's a commentary to our society. It's a commentary to the systems that the Crown governments have built and maintained over decades. That when a chief and council gets elected, they appoint someone to the child welfare. That's not on them. Society is more inclined to blame First Nations for that scenario. That's on us. The housing situation, on us, on the federal government. And I know the government's going to say, well, the province has invested more in on-reserve housing than ever. In fact, it's a federal issue, and so I celebrate that. However, the reality is far greater than the resources that have flown to the First Nations communities. But we cannot fix what has been broken over decades. We cannot fix it by simply handing jurisdiction back. We cannot simply fix it by focusing only on child welfare. It needs to have a full breadth scope view that the health and well-being includes a good home, includes a good education. We talked about in that last bill. It includes connection to your identity, of who you are, and to your family. It requires a government that respects the relationship between parents and their children, which has been part of the deliberate attack of Crown governments over decades, is to undermine that and erode it. That was in great extent what the residential and day school system was about. So I will take my seat on this. I will actually make one mention, and this is something that I think, and I'm going to put this on the record because these are the types of things that need to change. We got a briefing from the government on this, and in the briefing documents, there was a rationalization that was made that under the engagement with Indigenous partners, that due to the technical nature of this amendment, minimal feedback has been received. That the reason why there was minimal feedback received to this consultation was due to the fact that it was too technical. What am I to read into that comment? That I don't understand it? That the people who are working in child welfare in our communities don't understand technical things? Perhaps it was not intended to come off that way. But I can tell you the feeling that I had when I read it was that I'm not able to navigate, or my relatives in communities across the province who have been working on the front lines of child welfare didn't engage with this because they were confused. There's nothing in this about the timeline to engage. There is an acknowledgement here quite thoroughly that Indigenous governing bodies approached the government wanting this, and I assume that wanting these changes to be made, and I assume that those were Indigenous governing bodies that were further in the process. We'll hear about that as well. But I did want to make sure that this was on the record in my second reading speech, because it is the kind of language that, well, frankly, it's the kind of language that we're talking about. It's the kind of way that the Crown government frames Indigenous people. It's the kind of thing that needs to change. It could have been that the notification went out and 20 minutes later it was closed. I don't know. It could be that it's very technical in nature. However, I can tell you that whatever the intention was and how it landed, I'm hoping what was very different the intention of it was. But what it left was that these changes were so bewildering, nobody understood what they meant, so nobody engaged in the process. And yet we know the reality that on most of the notifications and engagements, in most of the notifications and engagements, it's the pile is this high on the desk. And there's one person sitting there, two people sitting there toiling away, working through the notifications of a Crown government that's moving quickly, that wants to get on with the business, that wants to get moving, whose timelines are tightly controlled in this place and not or in the ministry and not the timelines of First Nations. I've raised this a number of times. We've entrenched a number of times 30-day notifications, 90-day notifications. The right to self-determination, you got 90 days to respond. If you can get through the pile, and I think every one of us that has relationships with First Nations communities in our province knows that they are absolutely overwhelmed with the number of notifications and the lack of resources. And this is the reason why, when the jurisdiction and authority of child welfare gets handed from one Crown government to an Indigenous governing body, the resources need to go along with it so that there is the adequate financial and human resources available to be able to coordinate with the provincial government, the federal government when needed. So I certainly hope, and I'll ask this question in committee stage, I certainly hope that something completely other than what the feeling in our office was when we read through this, when we sat down and reflected on what this felt like, I certainly hope that the ministry meant something entirely different and that it was just we were reading it incorrectly. So with that, I will take my seat and look forward to the opportunity to engage with the ministry in committee stage. Hi, Squisiam.